I fell asleep and I woke up and he was dead in the suitcase, so I don't know what happened.
That's my name. Don't wear it out.
She's presumed innocent. She has a fundamental right to a fair trial.
I fell asleep. When did you do CPR? This morning, when I found it before you called. Yes!
Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Sarah Boone speaking out against a key piece of evidence as her murder trial is moving forward. And we should find out today if the judge will let it in. And Matthew Perry, again, trending in true crime. One of his doctors pleading guilty. But what about the second doctor and the ketamine queen? Also this hour, we've got a conversation with Diddy's detective. He arrested Diddy back in the 90s when he and J-Lo were a thing. And now this notorious COP is telling us why he knew that this investigation was coming. Plus, Trooper Michael Proctor, who we know from the Karen Reed case, could be tipping the scales in the case of Brian Walshe. It's all coming up next for you right here on Opening Statements. Good Thursday morning to you and welcome to Opening Statements. I'm Julie Grant. Are you ready for some coffee and court? We've got a great show planned for you, so let's start things off the way we like to do it around here. Go ahead and grab that cup of coffee. It's time for my opening statement. I thought the trial started early. What the heck was Sarah Boone doing on the witness stand? In all my years, I've never seen a defendant take the stand at a suppression hearing. That one was one for the books. And my guess is that it wasn't her attorney's idea to call her as a witness. I think he just probably took the path of least resistance with her and let bossy Sarah Boone do as she wished. And she did too much. She just couldn't help herself. She let it out that she was intoxicated at the time of the incident. And that is going to help the prosecution when she claims that she suffered from battered spouse syndrome. Mark my words, my friends. Because how was she perceiving a threat if her perception was impaired? She should have thought about that when she was trying to slip that into the hearing on Wednesday, to try to make it seem like she was pressured into talking to the police. We all watched that interview. She thought she was working them. She thought she was bossing them around. That is until they arrested her, right? Bossy Boone ought to take a seat and listen to her lawyers come Monday. But I have a feeling that that won't happen. And I think we're going to see the bossy one calling all the shots and taking the stand again. That's my opening statement, friends. Let me know if you like it. Right now, it's time for your daily docket.
Mr. Fiddles, are you high right now?
What kind of question is that?
Answer it, sir.
No, ma'am, I'm not. No, I'm not high.
Do you remember ever stating that I bugged out?
You did bug out.
At what point did I bug out?
When you had that damn gun in your hand.
We've got testimony resuming this morning in Ohio for the medical assistant murder trial. This is pro se defendant Quentin Nixon. His trial, it's going to convene at 9 a.m. Eastern. We'll go in live when it begins. And in South Carolina, we've got the state expected to rest its case in the jealous husband murder trial. That begins at 10 a.m. Eastern. And we're going to bring it to you live once it's underway. Then in Tennessee, we've got Karen and Michael Murray being sentenced for causing the death of their elderly mother. Remember that case? Court's going to begin at 1:30 p.m. Eastern. Now to our top story this morning. Days before jury selection begins in her murder trial, Sarah Boone taking the witness stand at her motions hearing. She's accused of murdering her boyfriend, George Torres, by zipping him up in a suitcase and leaving him in there to die.
I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
She and her new attorney, James Owens, want to get her 2-hour recorded interview suppressed. The defense is claiming that she was not correctly given her warnings pursuant to the famous case Miranda versus Arizona, and that she was coerced into the interrogation. Well, the judge has until the end of today to issue that ruling on whether the evidence will be suppressed. We'll let you know when we get that information. We also learned at the hearing on Wednesday that Boone is going to be makeup-free during her trial after her motion to have professional hair and makeup done was denied. Jury selection begins on Monday. Mark your calendars, my friends. All right, so let's talk about these things. Let's talk about the interrogation video, her taking the stand. No glam squad for Sarah Boone. Let's bring in our guest, criminal defense attorney and former prosecutor in Florida, by the way, Matthew Timpanic, and trial attorney Tad Thomas. Good morning to you, gentlemen. Matthew, let me start with you, please. Let's start with the Miranda warnings. And this officer leaving off the end of what was on the card that this department apparently uses. We have a photo image of it. I want to show it to you as we're discussing this, Matthew, this image of the card that police department uses there in the Orlando area. And that last line, do you understand each of these rights? I've explained to you. Having these rights in mind, do you wish to talk to us now? That was not said. Matt, does that mean that the whole interview gets tossed, or was she properly advised of her warnings pursuant to Miranda?
This is a very interesting issue. I believe there's actually a U.S. Supreme Court case on this very topic. So when you're given Miranda, you have to, there are two parts of it. One, advising them that they are under investigation and they're about to be asked potentially incriminating questions. The second part is a waiver of that right to remain silent. So you can read the first part, but if you fail to read the second part, the waiver aspect, it could be seen as not an intelligent, voluntary waiver of your right against self-incrimination. It sets up a very interesting issue, and one that did not need to happen, and it was a potential unforced error in the prosecution's case.
Right, Matt. We have the video. Let's look back at exactly what the officer did and did not do.
Just like we did yesterday. Remember I read you the rights? Your rights? Yeah, so it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? Sure. All right, so you have the right to remain silent. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me?
No.
And do you understand what I just read you?
Yes.
Perfect. Okay.
Okay, Tad Thomas, I want to go to you next. What do you think the judge should do here?
I think the judge should and will probably keep these statements in. You know, the question is did she understand that she was going to be giving information to the prosecutors, to the detectives that could be used against her in a court of law? She clearly said that she understood that. I think this current Supreme Court, if this case were to go back up on Miranda, this current Supreme Court is not going to say that Miranda was not properly used in this case. They're going to say that she understood her rights and that everything should have come in, and I think the judge is going to let it in.
I'm with you, Ted. I think so, too. I just have that feeling. Let's take a look at a little more of what she said in her interrogation to those officers.
Was there any discussion about you being interrogated at the Sheriff's Department?
No.
Was your understanding the sole purpose of you going to the Sheriff's Department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Kupsel was pregnant and not feeling well?
Correct. I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like for you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did.
Okay, so obviously this is from her testimony. She's referencing the interrogation video, so that's a good clip for us to look at as well here. Matt Timpanic, let me go back to you. In all your years of practice, have you ever seen a defendant be called in a suppression hearing?
No. And the reason is this, especially in advance of trial. She is good. Remember, the defendant has an absolute right to remain silent and not be a witness against himself. She has now given up that right. So at trial, an argument could be made that everything she said during that suppression hearing can come in as a statement against penal interest or a statement against an unavailable defendant on an 804 exception. The reasoning is that she has given up her right to remain silent. She's not going to testify again, and there's potential admissions, what she was saying, that she was intoxicated at the time. That would go forward for the prosecution's case. What I can tell you, there is very little good testifying at a suppression hearing this close to trial. And for the prosecution, it's pretty much Christmas come early.
Right, Matt Tympanik. I love it. Tad Thomas, let me go to you and ask you about the Glam Squad denial. So Sarah Boone was requesting professional hair and makeup. It seemed like for a moment maybe the judge was going to consider it. Then, of course, we know the sheriff's department spoke up, prosecutors, about this being a security issue. It could be a security issue for an inmate to have that happen. And so the request was denied. Your thoughts on just in general the ask, first of all, and then second of all, the judge's decision to deny it?
First of all, the ask is very unique, just like Mr. Morano said about the testifying at the suppression hearing. Never seen that before. Never seen anyone ask for professional makeup, not just to do it yourself, but professional makeup artists to come in. And as far as the judge is it's really interesting. Judges do not want to be reversed, especially on criminal cases like this that are so serious. So they take every precaution to try to be fair. So this judge was clearly thinking, gosh, what if the Court of Appeals said that, this was a reasonable ask? And he considered it for a long period of time. And then most judges look for something to hang their hat on when making a decision. And so when the sheriff's department spoke up and said, hey, this is contraband, we don't allow this in the jail, that gave him, good cause to say, no, we're not going to deviate from policy and procedure on this.
Great points, Tad. Thank you for all of that. So it all starts on Monday. Sarah Boone on Monday. And my next question before we end the segment is, do you think her getting on the stand during the suppression hearing is an indication for us that we're going to see her testify at the time of trial? Matt?
I think she can't help herself, honestly. A defendant has the absolute right to take the stand in their own defense. It rarely ever helps. And if she's testifying in a suppression hearing, you can bet, sure as the day you were born, that she will be on that stand to testify in her own defense. She probably shouldn't, but I don't think she can help herself.
I agree. Tad Thomas, quickly, do you agree too? We're going to see her testify.
I agree 100%. Your opening statement was right on point, Julie.
Oh,
this was her call, not the lawyer's call.
Oh, thank you so much. Well, great insight from you very seasoned attorneys. Buckle up. Let's get ready to go. Monday is the day. Tad Thomas, Matt Tympanik, you both are sticking with us. Thank you for that. I want you to do the same at home. Go refill your coffee or something. When we come back, we're talking about what is trending in true crime.
These defendants took advantage of Mr. Perry's addiction issues to enrich themselves. These defendants were more interested in profiting off Mr. Perry than caring for his well-being.
One of the doctors charged in Matthew Perry's death pleads guilty. What that means now for the other defendants. And we have a very special guest joining us to talk about the latest Diddy developments. He is the officer who arrested Diddy back when he was with J-Lo.
Sarah Boone is charged with second-degree murder after her boyfriend suffocated inside of a suitcase.
He's in the suitcase still. There are multiple domestic violence incidents.
You two hitting each other. Sarah. It's my name. Don't wear it up.
He's telling you, Sarah, I can't breathe.
George Torres locked inside of a suitcase, begging for help.
I thought he was okay.
The Suitcase Murder Trial. Live coverage starting Monday morning, 8/7 Central on Court TV.
Call now.
Now for what's trending in true crime, a doctor who admits to giving actor Matthew Perry ketamine injections has reached a plea deal with federal prosecutors. Dr. Mark Chavez pleaded guilty to conspiracy to distribute ketamine and becomes now the third person pleading guilty in the Friends star's fatal overdose last year. In court documents, Chavez says that he obtained the ketamine with a fake prescription. Here, prosecutors describe how it all worked.
This network included a live-in assistant, various go-betweens, 2 medical doctors, and a major source of drug supply known as, quote, the ketamine queen. These defendants took advantage of Mr. Perry's addiction issues to enrich themselves. They knew what they were doing was wrong. They knew what they were doing was risking great danger to Mr. Perry, but they did it anyways.
Now, prosecutors are building their case against the two key players, Dr. Salvador Plasencia, who is charged with illegally selling ketamine to Perry in the month before his death, and Jasveen Sangha, also known as the ketamine queen of Los Angeles, who authorities say sold the actor the lethal dose of ketamine. Both have pleaded not guilty and are awaiting trial. So we're asking the question, will those final two defendants cop a plea before trial? Let's bring in our power panel. Still with me, criminal defense attorney and former prosecutor Matthew Timpanik, trial attorney Tad Thomas, and private investigator Robin Martinelli. All right, Tad Thomas, would you start us off? Do you think these two are going to trial, or you think they might take a plea?
You know, it's shaping up that a plea might be a better idea at this point. You know, anytime you have all these other pleas and you have co-conspirators who are willing to testify, it makes it a real uphill battle for the remaining defendants.
Yeah, it really does. You know, this is a case where they've identified this ring, how it all worked, from where it originated, how it was distributed, how it was administered. They are all caught. Matt Timpanik, does that incentivize defendants? Do you think these two might say, oh, geez, 3 in our ring pleaded, and now, you know, even though we're cloaked in the presumption of innocence, you know, we're kind of tied in to these admissions by these other defendants in the group?
And it's also, remember, when a defendant decides to plead guilty where there's multiple co-conspirators, alleged co-conspirators, there's usually an agreement to cooperate and testify against those who are remaining. Thus, so 3 individuals have previously pled with 2 remaining. Those 3 individuals have pled. Their plea agreement most assuredly includes a provision that if the other case would go to trial, they would testify against them. So they have every incentive in the world to cop the plea now before it goes to trial and they get potentially worse, or they are in a situation where they're the only one left standing against 4 other people who says, yeah, they're involved. Who's the jury going to believe? Probably not the defendant in that case.
Great points, Matt. Thank you for that. Robin Martinelli, let me go to you next, please. Your thoughts on whether we're going to see some deals struck?
You probably will, because following the evidence, you can probably see why the first person may have pled. But following the evidence of culpability and liability, they have to wonder, okay, this one's already pled. So who comes to the table first is usually the one that gets the better deal. But there might be some more investigations, and I don't know if there's going to be more people involved or more situations, but I would think that they want to do a little bit more investigation before they pled for their 2.
Yeah, you know, how strong are the cases against these two? Robin, appreciate that. You know, are they the weakest cases of the 5? You know, when this big announcement was made by the federal government, I remember everybody thinking, you know, thank goodness this was looked into, because Matthew Perry was such a beloved actor in America who struggled and was trying so hard to battle addiction and overcome addiction, and America was with him in that fight. And to see this happen and to see people being held accountable was something that was really remarkable after so many months. And then you have 3 people coming with admissions, owning it, and then the other 2 allegedly connected want to fight it. Is it because the cases against them are weaker? Let's talk a little more about Dr. Chavez to perhaps answer that question. So this guy, he's got an impressive background. He's an ER specialist with 19 years of experience working in the medical field. He has a degree in biochemistry. He authored a book called 5 Habits of Healthy People. But prosecutors say, you know, he conspired with the other defendant, Dr. Plasencia, and that they sold Matthew Perry overpriced drugs. The 2 allegedly charged the actor $2,000 for a vial of ketamine that cost Chavez just $12. So how does a doctor become a drug dealer? Let's tackle that question. Let's bring back our power panel. Robin Martinelli, I want to start with you this time. Your thoughts on that?
Well, ketamine is a very, very strong drug. Ketamine is like a horse tranquilizer. So, you know, it's not so much as a street drug as it is pharmaceutical. And if he was trying to profit off that and even had mules helping him or helping him to pass his name on, there could have been a lot more damage done. And so I think they're trying to send a message that says, okay, if doctors can do this, is it going to keep happening? Unfortunately, he is the one that wanted to go further and give more drugs and make money off of it. But he realized that somebody's life was lost. And you know, he was famous, but Matthew Perry was, and he was dealing with addiction. So he is a doctor. I think he gave up his license. I think he gave up. He did a lot, and just don't know how it's going to pan out with him coming to the table first.
I appreciate that, Robin. Matt Timpanic, I'm going to go back to you here. Your thoughts on how someone who has lived a very helpful life, Dr. Chavez, our example here, somebody who's served people for many years in the ER, 19 years in the ER. He's authored a book. How we see the turn to engaging in criminal activity, taking advantage of people, and essentially putting profits over people.
I definitely think that it's kind of twofold. Like you said, profits over people, selling pretty much markup, like when you have a $12 drug selling for $2,000. But also, I think it's kind of that relationship. He's selling drugs to a celebrity and kind of like getting off on that and being able to tell other people that that's what I'm doing. Oh, guess who I'm dealing with? Guess who I'm treating? When in reality, he's kind of he's not helping his patient at all. If you want to consider him, he's become not only doctor who helps people, he's essentially become Dr. Death in these types of situations. And I think at sentencing, which eventually the judge is going to give him some credit for cooperating and pleading guilty, but the judge at sentencing is going to see this as a complete betrayal of everything that he once stood for and now doesn't.
Right, Matt. Thank you for that. Tad Thomas, I want you to take us home here. This was something that I read that angered me when this case first was announced by the U.S. Attorney's Office, and it was text messages between the two doctors. So we have Plasencia, who has not pleaded, and we've got Chavez, who did plead. And in one of the messages, Plasencia texts Chavez and says, quote, "I wonder how much this moron will pay." Talking about Matthew Perry, talking about taking advantage of him. Let's say Plasencia goes to trial. Can you imagine what effect that message alone is going to have on his jury?
You know, the question itself, you know exactly where this is going. How bad is that text message in front of a jury and in front of a judge? You know, this judge is going to see that. He's going to know this is all about profit. Ketamine therapy is an appropriate therapy. There's a right way to give it. It's, you know, medically administered by a physician in a controlled atmosphere. And, you know, it can be very helpful in certain situations. This is a greedy doctor who will do anything for profit, and it took someone's life. And that text message says everything about this doctor's mental state.
Great points. And we know that this ketamine queen, as she's known in LA, is known as the one providing the lethal dose. So that also is something that could potentially, you know, maybe inflame this jury if, you know, if she goes to trial and if they think that she was the one who gave him that lethal batch. These are the allegations. These two cloaked in the presumption of innocence, but we will see if they strike up any agreements. Of course, if we learn of any, we're going to report them here on Court TV. A big thanks to you all. Great discussion. I know we have to let you go. Matt Timpanic, thank you kindly. Robin Martinelli, thank you much. We hope to see you both back very soon. Tad Thomas is coming with us. I want you to do the same, please. When we come back, we're talking to the NYPD officer who arrested Diddy back in the day. He arrested J-Lo, too. Going back to the 90s in our next segment and talking about the rap music mogul and how we got here today. Plus, how Trooper Michael Proctor, famous for his role in the Karen Reed case, could tip the scales in another very high-profile murder trial. Welcome back. We're spotlighting the firestorm surrounding music mogul Sean Diddy Combs. In the wake of more than 100 new sex assault allegations, we're wondering how dangerous really is Diddy? Now, he's been denied bail twice, we know, by two different judges. This week, his legal team, by the way, submitted a notice of appeal to the U.S. District Court trying to reverse those rulings and get him out. He's being held in federal jail, the Brooklyn Metropolitan Detention Center, and he maintains his innocence. Now, before we start talking about his upcoming federal case, let's look back a little bit at the turbulent times of Sean Diddy Combs.
It's so difficult to reflect on the darkest times in your life. Sometimes you gotta do that. I was disgusted then when I did it, I'm disgusted now.
As alleged in the indictment, to carry out this conduct, Sean Combs led and participated in a racketeering conspiracy that used the business empire he controlled to carry out criminal activity, including sex trafficking, forced labor, kidnapping, arson, bribery, and the obstruction of justice. The indictment alleges that Combs abused and exploited women and other people for years, and in a variety of ways. As alleged, Combs used force, threats of force, and coercion to cause victims to engage in extended sexual performances with male commercial sex workers. Agents seized evidence of the crimes charged in this indictment. They seized firearms and ammunition, including 3 defaced AR-15s and a large capacity drum magazine. They also seized evidence of the freak-offs, electronic devices that contain images and videos of the freak-offs with multiple victims. And they seized cases and cases of the kinds of personal lubricant and baby oil that Combs' staff allegedly used to stock hotel rooms for the freak-offs, more than 1,000 bottles altogether.
There's nothing that the government said in their presentation today that changes anyone's mind about anything. He's been looking forward to this day. He's been looking forward to clearing his name, and he's going to clear his name. And we're going to stand by his side as he does. We believe in him wholeheartedly.
Our youngest victim at the time of the occurrence was 9 years old. We have an individual who was 14 years old. We have one who was 15. 25 of the 120 individuals who are plaintiffs in these cases were minors at the time of the acts complained of.
He believes he's innocent. I believe he's innocent. And we're going to fight this case with all of our might until we don't have to fight anymore.
We have a very special guest we want to welcome in now. He's a retired NYPD detective, widely known as the hip-hop cop, Derek Parker. Derek, good morning to you. Thanks for coming on Opening Statements.
Good morning. How are you?
I'm wonderful. Thank you. Let's take a trip back to the 90s together, please. Back in the 90s, set the scene for us. I understand that you were tapped to start up the NYPD's Rap Intelligence Unit.
Yes, I was given that task to create this unit to deal with the violence in the hip-hop community and to provide a better understanding of what went on for the police commissioner and the chief of department.
So then how did you get in contact with Diddy for the first time? What was the first time you two crossed paths?
Well, I've been watching Diddy for a while, back in the 90s, and one of the bigger events that I had was the shooting at Club New York involving himself with J-Lo and Shine. I was tasked to go there, and I got a phone call in the middle of the night to get up and go to the city because this happened. And when I went to the precinct that night, it was very chaotic because all the lawyers were outside and they were all applauding me, saying somebody with brains has finally showed up. We want to see our client. It was really, really a chaotic scene. So basically what happened was that there was a shooting inside the club where Diddy, I call him Puff back then, was in the car with J-Lo and Wolf, his bodyguard. They took off and left, and Shine, who was with them, apparently came out with a gun in his hand, and the police arrested him on the spot. And then what happened was that while they were in the precinct, they brought J-Lo and Diddy back with Wolf to the Midtown North precinct. And when they brought them back, I spoke with them very briefly, and then we transported them back to Midtown South. That was when the precinct of occurrence was. And then the DA came in, and then he handled the case from there, and then they did the interviews, and then we went from there and handled that case.
Did you agree with how that case wound up proceeding against Shine?
Well, I have to say that, Shine was caught with a gun that night. So it happened with him. I can't say he's totally innocent, but, it went the way it went. I mean, it was very difficult because there were conflicting statements from witnesses that said what Diddy did. One person said he had a gun. Some people said he didn't have a gun. It was just a lot of things going on back then. The DA had a very tough time to prosecute that case.
I was going to ask you about that, Detective. Weren't there two guns, according to some accounts, that Shine had one and Diddy had the other?
Well, the other gun you're talking about was probably found in the car that they were traveling in. That was the second gun that had been found that night. So the police had recovered two guns. You're correct in that.
Gotcha. And so, Detective Derek, so that was the first time you crossed paths, and then along the way, I understand you had more and more interaction with him, more arrests, so many so that you started getting the nickname Diddy's Detective. Tell us kind of how that happened, please.
Well, what happened was that, I've been following Diddy for a while. I mean, the East Coast, West Coast war was in the early 90s when that happened, out there with Bad Boy Records and then Death Row Records with Suge Knight. So, I mean, I traveled to Los Angeles and to Las Vegas back then, but I followed Diddy. I followed his career, and every time he got into trouble, I would get called by the chief or the chief of detectives or the PC. The police commissioner would call me as well when he wanted information about what went on with this individual. So he had the Steve Stout assault at MTV with the MTV thing, so I had dealt with that. But it was a lot of things that people started nicknaming me Diddy's Cop, because every time he got into trouble, I was there. I had to be there to give the brass and the department an update on what was going on with him and why these things were happening with him.
Mm-hmm. Detective, tell me, when Tupac was shot at the recording studio in New York, and at the same time he was shot, we know Diddy's in the building, were you called in to investigate that?
I was on the phone with the detective that was responding to that scene, and I told him it was going to be very difficult for him to really get a handle on what was going on, because, people had called me and told me what was going on with that shooting at the Tupac studio. So I knew it was going to be very difficult to get Tupac to cooperate and to say who shot him. And there was always some banter that he may have shot himself when he pulled his gun out as he was being robbed. Mm-hmm. And that was always the case back then.
I think he did, right? I think that was documented that he did accidentally shoot himself in addition to being shot by someone else.
That is
right,
correct.
right. Thank you for that, Detective. And so then, here we go. Things progressed, right? The rap wars, as you know, the East Coast, West Coast rivalry, and then Tupac is killed. Were you consulted on that? I'm so curious if you were consulted as to what you may have known about Diddy at the time.
Well, I went out when Tupac was killed, I had told my superiors here in New York that we were going to have a problem with this. And I keep remembering this same line. My inspector said, Derek, listen, they don't kill people in rock and roll. Why are you involved in this? And I said, well, this is going to be a big deal, because I was in the cold case squad. I was doing unsolved homicides for a long time. And my captain didn't really want me to be pulled over into this rap intelligence thing, but it just happened. And then when Biggie Smalls got killed, that was the biggest problem that we had in New York, because I had to formulate a plan for his burial and for the funeral, and for all the threats that were being given out to Diddy, to Little Kim, to several people involved in his entourage at this funeral. And that's when we had a big problem in New York, where we had to come up with an attack plan to make sure that everybody came here that was safe and that we had any problems, and Diddy wasn't really assassinated by some people that wanted to get at him.
Mm-hmm. I'm so glad you offered that, Detective. Thank you. That was going to be the next thing I was going to ask, your involvement when Biggie was killed. In your detective work, in particular, following Diddy, keeping tabs on him, knowing what's going on, investigating some of these incidents you mentioned, did you ever come across any information tying him to either the murder of Tupac Shakur or the murder of Biggie Smalls?
Well, I'll put it to you this way. The murder of Tupac Shakur was done by some individuals that were out in L.A. It's an L.A.-based informational about the people that were involved. Diddy, yes, Diddy had some beefs with Tupac back then, but to say that he was directly involved in that right now, that's too premature to say that. There's been a lot of talk about, this payment for assassination against Tupac that maybe Diddy provided, but that's really inconclusive right now. We have to see how that really forms out. As far as the Biggie case is concerned, the individuals that were involved in that, one of the individuals is dead, from what I know. And in the Tupac case, 3 of the individuals are dead, and there's only one person that's still alive, and that's Keefe D, and he's going to be going on trial next year sometime for the murder of Tupac.
Right, Detective. And as you said, a big question is whether or not information may come in about any alleged payment, allegedly for $1 million for the deaths of Tupac Shakur and Suge Knight. Was that statement made by Diddy is a big question here. I'm wondering if we're going to get some answers. Detective Derek Parker, I have so many more questions for you. You have lived a fascinating life. You've written a book about some of your casework. Take a look at this. I got it up on the screen. Notorious C.O.P. Inside the story of the Tupac, Biggie, and Jam Master Jay investigations from the NYPD's first hip-hop cop, Derek Parker, with Matt Deal. I can't wait to read your book, and I'd love to have you come back on the program. As you know, this investigation is quite voluminous, and we have the trial of Keefe D coming up as well very soon, and there could be somewhat of an intersection, as you know, Detective, with cases. Thank you kindly, Derek Parker. I'm going to read your book soon. Come back again on the show, please.
Thank you for having me.
Of course. And coming up next here on Opening Statements, we've got attorneys for accused wife killer Brian Walshe wanting evidence relating to notorious trooper Michael Proctor. We know him from the Karen Reed case, talking about how his involvement in the Walshe case could potentially tip the scales for the defendant. That's next.
Sarah Boone is charged with second-degree murder after her boyfriend suffocated inside of a suitcase.
He's in the suitcase still. There are multiple domestic violence incidents.
You two hitting each other. Sarah. That's my name. The word up.
He told you, Sarah, I can't breathe.
George Torres locked inside of a suitcase, begging for help.
I thought he was okay.
The Suitcase Murder Trial. Live coverage starting Monday morning, 8, 7 Central on Court TV.
So don't spell it. You have to. So these are your words, Trooper Proctor?
Yes, Your Honor.
Go ahead and say them.
Yes, she's a babe. Weird Fall River accent, though. No ass.
Oh, my. Former trooper Michael Proctor could possibly be tipping the scales in the murder case of Brian Walshe now. The accused killer appeared with his attorneys in Norfolk Superior Court on Wednesday on their motion seeking access to various records relating to the disgraced trooper's investigation. Now, Walsh's defense team is looking for Michael Proctor's cell phone records, his job performance records, and any records from cases that he might have investigated, specifically the death investigations of Officer John O'Keefe and Sandra Birchmore, 2 cases we've obviously been talking a lot about here. Now, here's a quick look at Brian Walsh's appearance. It was before a judge you're going to recognize, the Honorable Beverly Cannoni.
Good afternoon, Mr. Walshe. Good afternoon. I think based on the representations of the Commonwealth, both in its communications yesterday and then today, there's a lot of discovery forthcoming, some of which addresses some of our requests, some of which probably don't. So I think it's a waste of our time to argue this extensive motion and memorandum of law. And I was going to explain why we filed such a detailed memorandum of law, but I don't think I need to waste the court's time with that. So I think what we're suggesting is, at least what we're suggesting, is that we come back on December 2nd.
All right, so Brian Walshe is accused of murdering his beautiful wife, Anna Walshe, back in January of 2023. And investigators believe that he hid her remains as well, as her remains have never been discovered. Now, he's being held without any bail. Still no trial date set for him, even though it's been a while. We understand that Judge Cannoni agreed to wait until December to hear that motion for this discovery that his defense team is requesting. So let's talk a little bit about Trooper Proctor and how his involvement in this case could potentially tip the scales of justice. I have a great guest standing by to help me do that. He's not only an attorney, he's also a law professor. Tad Thomas on the program with us. Oh, Tad, this is really something. This is a heinous case, as you know. It is believed that Brian Walshe murdered Anna Walshe and perhaps dismembered her body, according to some investigators' theories here. And they believe that her remains may have been placed around town, who knows, but never been discovered. And he's maintaining his innocence, and now it seems that he's looking for an advantage because Proctor worked his case. How do you see this going with them trying to get any information they can from Proctor in order to somehow use it to the defense advantage?
You know, it's not an unprecedented request, but it is very unusual for the defense to ask for this extensive information. Obviously, anytime you have a police officer or detective who has negative information against them and that pertains to their honesty, that has to be disclosed in every case. So now that you have this out there, it could be that the judge allows more information. I don't think the judge is going to allow this extensive information, but the defense was smart to not argue the motion right away because they looked very reasonable by telling the judge, hey, let's wait. We understand there's new discovery coming in. Let's wait, give us a chance to get through this additional discovery, see how many of these questions are answered that we have. And then we'll come back in December, and if we think we need to argue more and get more, we'll ask for it then.
Excellent points from you, Ted, as per usual. So at the end of the day, in the Karen Reed case, when it comes to Proctor, I mean, he ended up getting a very bad reputation for this. It was unprofessional. It was uncalled for. It was shameful, really, you know, and it also exacerbates any distrust that is out there for police, that he was talking about Karen Reed in such a disparaging way to family members. You know, they shouldn't have been hearing this stuff, or friends, or, you know, everything professional should stay professional. But when you really cut all through it, the Reed team was alleging that he tampered evidence, and there was no evidence that he did. No evidence whatsoever put into a court of law through that trial that he tampered with anything. So it was kind of like he got the what do I want to say? The unlikable, or just the bad reputation, you know, for, I guess just kind of being a jerk or name calling, all that, just because of what he said in the personal text, not because he tampered or placed anything anywhere. I'd like your thoughts on that, please, Ted, when it comes to what can happen with Brian Walshe, because it seems like, are they looking for the same kind of thing here?
Yeah, I think what they're looking for here is, you know, a detective has to be neutral. They have to follow the evidence. And if they are found to be biased and have predetermined, predestined, preordained the outcome of an investigation, that is what can be attacked here. And so that appears to be what the defense is looking for in the Walshe case is, hey, were there other potential suspects that were never investigated, so that they can draw reasonable doubt by pointing the finger at someone else without any evidence maybe, but just enough to say that the detectives didn't go out and get it. It's not the defense's responsibility to go out and investigate those other potential suspects. It's the detective. And so if they can say that the detective had preordained this investigation, then it could lead to reasonable doubt in at least one juror's mind, and that's all they need.
Right. Yeah, great points. You know, and I guess one big difference here, too, Officer John O'Keefe was a victim known to Michael Proctor. It was very clear he felt something kind of personal, being that this was another police officer victim. So another difference in these cases that are now being so closely compared. Big thank you to you, attorney and law professor Tad Thomas. We'll look forward to having you back very soon. That is all for this episode of Opening Statements, friends. You can watch it again if you want. Just go to CourtTV.com, click on the Shows tab. Up next, it's Court TV Live.